Okay, good evening, everybody. Welcome to the Doughty Street seminar on possession and the cost of living crisis. My name is Ben Chataway and I'm part of the Housing and Social Welfare team here. I've got some good news and bad news this evening. The bad news is that you were promised Martin Westgate, King's Counsel. Unfortunately, Martin can't make it this evening, so instead you're lumbered with me. But the good news is that the important people are also here. They are our two expert speakers, Daniel Clark, Marie Paris. I expect most of you'll know Dan. He'll be drawing on his encyclopedic knowledge of housing law and recapping on some older issues to do with possession and rent arrears in the light of the new crisis. And probably many of you now will also know Marie, who's our newest recruit to the Housing and Social Welfare team here. And Marie's going to be drawing on her own experiences, including as a duty advisor, to look at some practical issues and some possible sources of help. So just before we start, two things. Firstly, that the seminar will be recorded and will be available on the website. Secondly, that if you've got questions that you want to raise, please do raise them and use the Q&A function at the bottom of Zoom. And what we'll try and do is perhaps go through and answer some as we go along using the Q&A function. And also, we hope, deal with some other questions at the end, as I hope, because we're going to aim to finish at 7 o'clock sharp. So without more ado, I'm going to turn to Dan.
Thanks very much, Ben. I accidentally managed to touch my mouse and advance slightly early to the overview of what's going to come, but now's a good point to deal with it. Yeah, as Ben discussed, going to split broadly into two halves. I'm going to deal with territory which will broadly be familiar to all of you, about the rent arrears grounds, when rent is lawfully due, and some specific issues in relation to utilities and rent increases, before Marie looks at the other side of the scales, so to speak, in terms of how clients can maximise their income to try and address rent arrears. So starting then with the kind of most basic rent arrears grounds under the Housing Act 85 for secure tenants and the Rent Act 77. We're looking here obviously at ground one under the 85 Act and case one under the 77 Act. And the ground to be made out there is that rent lawfully due from the tenant has not been paid. And there are a couple of points that arise here. The first, which I have to say is one of those which I think I perhaps kind of didn't have the top of my mind until I was looking at it for this seminar, is, of course, the ground doesn't specify the date on which rent is to be unpaid. And so on the face of it, the court has to be satisfied as the ground at the date of the hearing. But in fact, there's authority, at least under the Rent Acts, case Bird and Hilditch, which suggests that the rights crystallise at the point of issue of the proceedings. So if there's rent owed at that date, then the ground's made out. I'm not aware that there's any authority under the 85 Act about that, but certainly it would seem that would be the position. However, on the other hand, if you've got a case where there were rent arrears at the date of issue and they've sort of been cleared by trial, there is authority to say that prima facie it would be unreasonable for the court to make an order for possession. That's the case of Delenti and Pello. Although the court did in that case suggest that even if the rent arrears have been cleared, if there are other matters, for example, a long history of non-payment, which then becomes a ground under the 88 Act, the court might nonetheless find it reasonable to make a possession order. In that respect, a further point, Flo, which is a point that I have often overlooked, but and is often overlooked by claimants certainly. A useful comment from Sir Richard Scott in the case of Reuchler and Lehman is that although reasonableness has to consider all of the circumstances, that is all the circumstances that the landlord has pleaded, and so it should be possible to resist if rent arrears have been cleared or mostly cleared. The landlord shouldn't be able to then just stick in a witness statement saying, well, actually, here are some other reasons why you should be granting possession order. Also a question starting from the kind of relatively simple words of the ground. Under the 85 Act, the requirement to serve notice of seeking possession, including particulars, what happens if there are rent arrears by the date of issue, but there weren't rent arrears at the date of the notice of seeking possession? There's nothing in the ground, unlike when we get onto ground 8 under the 88 Act, to say that there had to be rent arrears owed at the date of notice in order for the ground to be made out. But potentially in some circumstances, you might be able to say that the notice requirement hasn't been complied with in those circumstances, because the particulars that are given have to be accurate. But a lot's going to depend on the facts. The case of Dudley and Bailey, it was held that an honest mistake as to the precise sum. So I think there they included some service charges that weren't rent, and it was held that didn't invalidate the notice. So the 88 Act, things become a bit more prescribed, and obviously the three grounds that you'd be very familiar with: ground 8, which is 8 weeks or 2 months in most cases, or 3 months if the tenancy is a quarterly tenancy. Rent lawfully due from the tenant, again, and we'll come to that in a moment, is unpaid both at the date of the notice of seeking possession and at the date of the hearing. And there's the well-known authority of Matthews about when the date of the hearing is and when it can be adjourned properly by the court. But it's worth remembering that ground 8 isn't just the date of the hearing, not least because where there is a claim for set-off, which we'll come to in a moment, as a way of reducing the rent lawfully due, then it might be the case that if the arrears were only just over 2 months at the date of the notice of seeking possession, and you can knock them down a little bit by a set-off as at that date, but then they increase greatly after that by the time you get to the hearing, then you might be able to say, well, actually, although the arrears now are 4 months arrears, and although there was 2 months of rent that hadn't been paid at the date of the notice, actually the rent lawfully due at the date of the notice was under the threshold, and so ground 8 isn't made out. Ground 10, again, unlike the 85 Act, specifies that the rent has to be due at the date of the notice unless notice is dispensed with, and at the date on which proceedings have begun. And ground 11, of course, is that the tenant's persistently delayed paying rent regardless of whether there are now arrears. So all of those grounds require that rent is lawfully due from the tenant, and there are two parts to that. The first is that the rent is due from the tenant, and we know that means from the current tenant and not the predecessor in title. So, for example, where you have a succession and the original tenant was in rent arrears and family member inherits the tenancy, then the original tenant's rent arrears can't be used as rent arrears for the statutory grounds, and that's the case of Ticknor and Clifton. And similarly, where there's been an assignment, the case of Parry and Robinson and Wiley, says that the assignee the rent arrears due from the assignor are not rent unpaid by the tenant and by the new tenant, the assignee. And that's the case regardless of whether the tenancy is before or after the Landlord and Tenant Covenants Act 1995, and you get that from section 23. The second part, or the second issue that arises in relation to this, which I don't think, and Ben or Marie may know better than me on this, I don't think there's any authority, but it seems to me that from a construction of the Act, the grounds have to be made out in relation to arrears under the current tenancy. It may be that you can include their fixed term plus statutory periodic, but I think there's certainly an argument to say that if you have a succession of fixed term tenancies, that if the landlord doesn't seek possession under the first two, say, on grounds of rent arrears, that by the time you get to tenancy 3, the landlord can't then go back and include all of the arrears under all of the tenancies. And And you can see that when you start illustrating it with examples of it can't simply be rent arrears owed by that tenant, because it couldn't include, for example, rent arrears owed by that tenant in relation to a previous property that they rented from the landlord. It also, if the tenant rented a property and then moved out and then came back and rented the same property again, it presumably couldn't include old rent arrears. And I think when you look at the construction of the relevant sections and the grounds, there's at least an argument there. The other part is obviously not that it's only due from the tenant and possibly in relation to that tenancy, but also that the rent has to be lawfully due. And there are various circumstances in which rent is not lawfully due. So first, unless and until a landlord has given notice of their address for service under Section 48 of the Landlord and Tenant Act 87, rent is not lawfully due. But that's perhaps less of a knockout defence than it might first seem, because the landlord, once the landlord gives notice, all of the rent then is due. And in fact, the landlord can do so even after the tenant served a defence on that basis. And that's the case with Rogan. Rent's not lawfully due if it's based on an unlawful rent increase, which I'll come to it later. Also worth remembering, and this perhaps is not a viable solution in the majority of cases, particularly given the current cost of living crisis, but if a tenant pays money into court, then that won't be it, and the money's paid in to be held against potential liability for rent. For example, where there's a counterclaim and the tenant says, well, look, I think I'm owed a net payment in my favour for disrepair damages, say, but I don't trust that the landlord, if I pay the rent over, I'm never going to see it again. It's open to the tenant to pay the money into court, and then the court should not take that into account as rent lawfully due, because it's not outstanding in the same way. Also, most crucially and most familiarly, if rent is subject to a equitable set-off, for example, paying for disrepair damages, then that rent is not lawfully due. And that feeds into the point that I was making before about the date of the notice of seeking possession. And finally, this is likely to be rare, but if a claim for rent arrears is limitation barred, then it would seem that it can't then be used to found a claim for possession under one of the grounds, i.e., rent lawfully due is rent which could be recovered by way of proceedings. But the reason why I say that's rarely going to be of use is that although it's a 6-year limitation period, each new payment of rent can be apportioned by the landlord either to the most recent rent that's due, or to the oldest debt first, which then means that you effectively, unless you've got a very, very long period of non-payment and the landlord's done nothing, it's unlikely that you'll get to the stage where arrears are limitation barred. So that's dealing with what rent we're talking about and when and what is lawfully due. Looking then about when rent is due, the general rule at common law is that rent is payable in arrears unless there's agreement to the contrary, and that can be agreement in the tenancy agreement itself or implied from conduct. On the other hand, and this is perhaps more often going to be relevant, an accepted practice of late payment may result in the landlord being stopped from insisting on the strict rights to payment in advance. So where there is an agreement for payment in advance, the principle of estoppel may be engaged. See the case of Hazel and Akhtar. Also note that if a landlord refuses payments, then the tenant obviously in an ideal world should put that money aside and then can pay the money into court and rely on a defence of tender before claim, which would be a complete defence to the claim, even though there would have been some rent unpaid at the date of the claim being issued. Another point, which I think perhaps is it must come up more commonly than I have really thought about, because 1 in 30 rent arrears possession claims will come for hearing presumably on the rent day if it's a monthly, or even more frequently than that if it's on if it's a weekly tenancy. And often it won't matter because the client will be so far in arrears that it doesn't make a difference whether you're adding 1 more week or 1 more month. But the rent, although rent falls due on the day on the rent day, so on a Monday if it's payable on the Monday, or on the 1st of the month if it's payable monthly on the 1st of the month, say, it's not in arrears until the end of that day. So if your possession hearing happens on the rent day, then it shouldn't, the arrears shouldn't include the money that's become due that day, because it's not unpaid until the end of the day. Then there's also the point, and this is relevant really in relation to notices probably, and not hearings, because you won't have a hearing on a bank holiday, but the Banking and Financial Dealings Act says that where a payment of a sum is due on a bank holiday, then it actually becomes due the next day. So if you have, say, a notice of seeking possession that expires on a bank holiday Monday, and that would also be the rent day, say, then although the notice might expire on the Monday, the rent doesn't become due until the Tuesday. I mean, these are really cases where you're going to be kind of, where you're looking around for some technical point, because you might have a struggle on the more substantive merits. Also worth bearing in mind the rules about payment by cheque, which are handily summarised in the case of Avocet and Merrill. So very briefly, there's no entitlement to pay rent by cheque unless that has been agreed expressly or impliedly, including by conduct. However, even if you don't have a general agreement that the landlord will accept payment of rent by cheque, there might become an implied agreement to accept a cheque in payment of a particular payment of rent if the landlord doesn't reject that cheque promptly. An uncleared cheque is treated as payment at the moment of acceptance of the cheque, conditional on the cheque clearing, but it's paid when the cheque is accepted, unless later that cheque bounces. So that is useful in the circumstances where your client, if your client can kind of turn up to court with a cheque for something that takes them down below the ground 8 threshold, for example. Landlord, once the cheque has been accepted, either as part of a general agreement or a specific agreement in relation to a particular cheque, can't rely on their own failure to present the cheque for payment. Once they've got the cheque, the debt has been paid unless the cheque later bounces, regardless of whether the landlord presents it for payment. And there are also circumstances where there's an agreement not only to accept payment by cheque, but an acceptance by the landlord that the date of payment will be the date it's posted by the tenant, even if it never reaches the landlord. But that's much more difficult to imply on the facts. So then, in relation to the question of what is rent, which perhaps I suppose logically comes before some of the other points that we've been looking at. The question that often crops up is service charges and utility charges that are, most usually with public sector social landlords, you'll have a breakdown of the rent which says this much is for rent, and then this much is for water, and this much is for service charges, or whatever it might be. Under the Rent Act, there's a statutory definition which includes service charges and utilities within rent and then any arrears can be relied on for the purposes of the possession grounds. The question has, strictly speaking, been left open in relation to the Housing Acts, although I think it's fair to say that the Court of Appeal in Dixon gave a fairly clear steer that it thought these things should be treated as rent. And in any event, many tenancy agreements will include payment of service charges as another obligation of the tenancy, which would found a claim under Ground 1. The other thing to say about utilities is that there are all sorts of horribly complex issues that, I mean, you probably remember from a number of years ago, there were a couple of cases, which in fact Martin, I think, appeared in both of, Jones and Moss, which were about whether on the terms of the particular contracts between London boroughs and Thames Water, the boroughs were resellers of water for the purposes of the Water Industry Act 1991. The relevance of that being that if they were resellers, the Water Resale Order 2006 dictated the method by which they had to work out the price at which they sold it on to the tenants. And if they charged more for water than they were allowed to under that formula, then the additional amount would not in fact be lawfully due from the tenants. There's also there are similar provisions under the Gas Act 86 and Electricity Act 89, and I suppose that may become, particularly given the energy price issues at the moment, it may be worth having a look at those things. And there has in fact been some recent tribunal authority, so the case of King and Residential Marine Limited, which actually related to Mobile Homes Act, but talked there about an earlier case of McGregor, and about the climate change levy, and effectively that commercial landlords couldn't pass on to their tenants a share of the climate change levy that they had to pay as part of the utilities costs that they were paying. So it's worth looking at. As I say, it's rather complicated, and it often it's often going to reduce the arrears by a relatively small amount. But I certainly, I haven't run one of these cases in quite a long time, but I certainly did have some success in, at the very least, the work that landlords have to go to prove that their charges are lawful is often relatively significant. And in the meantime, obviously, your client can be taking steps to resolve the rent arrears in other ways. And in fact, the additional benefit, as I said in the final bullet point, is that under the relevant statutory provisions, the tenant can request details of the calculation of the charge, and if it's not provided promptly or within a set period under the Water Resale Order, there is then a reduced cap on the charges is applied until the information is provided. So actually, the delay in social landlords providing the information is not just helpful to give your tenant time to resolve things, but also can have an actual direct financial benefit in the meantime. Quickly then, because I realised that I'm slightly over time, I'm going to deal with rent increases. So first, under the 85 and 77 Acts, in relation to tenants protected under the 1977 Act, it's very straightforward. The rent that's lawfully due is the rent that's registered under Part 4, and there are no exceptions for other methods of increasing the rent. And so it should be, although those cases are rare, it should be relatively straightforward to work out what the what the rent lawfully due is, and whether any increase is valid. Secure tenancies, Section 24 of the 85 Act requires a local authority to fix a reasonable rent, and in theory it's possible to bring a public law challenge to that, either as a standalone JR or as a defence to a rent arrears claim, but it's very difficult to do so. And so, yeah, look at Wandsworth and Winder for an example of where that was tried unsuccessfully. Potentially more fruitful are the challenges that are based on the procedure for variation. So even if the actual amount that's decided on is reasonable, the correct process has to be followed. So Section 102 of the 85 Act says that there are 3 ways in which the terms of a secure tenancy can be varied. By agreement, so if the tenant agrees to an increase, in accordance with the term of the tenancy, or for a periodic tenancy by notice of variation under Section 103, and that's the most common way really in practice. But if you look at 103, there are certain requirements set out, so it has to specify the variation and the date and give at least 4 weeks notice, and if that's not followed, then the rent increase won't have been lawfully affected, and the additional amount won't be lawfully due. And the power to vary may also be restricted by a tenancy agreement. So some tenancy agreements say, for example, that the landlord won't increase the rent more than once every year. And so if there's anything, even if it's just a week inside that date, for example, you might be able to say that it's not a lawful increase in light of the terms of the tenancy. In relation to the 88 Act, and this is the penultimate slide now for me, fixed term assured tenancies, there's no statutory provision, so it all depends on the tenancy agreement. And the case of Riverside and White gives some helpful guidance about the construction of the tenancy agreement and whether or not a rent increase is in line with it. For periodic tenancies, the position is governed by Section 13 of the Housing Act 88, unless the tenancy itself governs rent increases or rent reviews. But it's worth noting that that exemption doesn't apply to statutory periodic tenancies. And so for a statutory periodic tenancy, even if there was a rent review term in the original tenancy, Section 13 is the governing provision. The other exception to it is that if the tenant agrees, landlord and tenant agree on a rent increase, then that's effective. But Riverside and White in the Court of Appeal said that had to be a proper contractual agreement, including some form of consideration on both sides, and also that the landlord couldn't claim that the tenant was stopped from agreement because they hadn't challenged some otherwise defective increase. So then looking at Section 13 itself, very briefly, the landlord has to serve notice in the prescribed form proposing a date for the rent increase, which has to meet the relevant criteria, and essentially the most important one being it can't be more than once a year, in effect. The tenant can then either accept that rent increase by letting the notice expire, or can apply to the First Tier Tribunal for a determination under Section 14. The tenant has to do so before the notice expires, and there is no power to extend that period. That's the case of Leicester. And if an application is made, then the tribunal will determine the rent at which the property might reasonably be expected to be let in the open market by a willing landlord under an assured tenancy for the same period on the same terms. So useful perhaps in relation to assured tenancies, less useful perhaps in relation to assured short holds, because actually if things get too complicated, the landlord may well just serve Section 21 notice and terminate the tenancy and find somebody else who's willing to accept the rent that they've laid down. I've also mentioned there that in the first 6 months of the tenancy, a tenant can apply under Section 22 of the 88 Act for a determination of whether the rent is excessive. But again, that's probably going to be of limited practical use for the same sorts of reasons. So with that, I'm going to hand over to Marie, who's going to deal with ways in which the tenant might be able to increase their income or find other ways of paying the rent.
Hi everyone, thank you Dan. Dan's going to stick around to help me manage the slides, I think. So I'm going to be talking about situations where there's not much you can do to argue about the amount of rent that's being claimed, but you can try and reduce the rent going forward. You are all probably more familiar than I am with these provisions by now, but I think it's worth remembering, and there have been some recent changes to the benefit regulations which could help and yeah, are worth bearing in mind. So I'm covering here the local housing allowance, which I think is going to be the provision that causes private tenants the most grief and possession claims, especially as rent increases are happening in a massive way at the moment. So there are going to be more and more instances where they come against the local housing allowance. The general rule is that it will apply, that the shared accommodation rate will apply if you are a single claimant or a couple without dependents and you're living in shared accommodation. I think that's unsurprising. The bigger problem is if you are a single claimant without dependents and you're considered a young person in the regulation, so under 35, and you are in any accommodation. So that's shared accommodation or otherwise. So most single claimants, or a lot of single claimants, will be in one bed self-contained accommodation, which will charge a market rent, and the local housing allowance is not going to come anywhere near it because they'll only be giving you what they consider the market rent for shared accommodation. So it's always helpful to bear in mind the exemption to the local housing allowance and make sure that the housing benefit is being, or the universal credit is being correctly calculated, because as you all know, it often is the case that there are mistakes. Oops, sorry, Dan. There you go. So for those who do live in shared accommodation, there are ways outside of it. So the first is if you qualify for the severe disability premium. So on that note, it's always helpful to make sure that your client has applied for every benefit that they may be entitled to, because the severe disability premium will only apply if you either get the daily living component or PIP or DLA at the middle or the highest rate, I believe. So it's worthwhile to make sure that they are getting the absolute the most they can get under the disability benefits, A, to help maximize their income, but B, to make sure that they may be able to get outside of the local housing allowance shared rates. The other exemption that applies that I think is often overlooked is if a claimant is under 25 and when they were age 16 or 17, they were subject to a care order, or they were accommodated for any point under Section 20, they will also be exempted from the shared accommodation rate, regardless of whether they're living in shared accommodation or not. For those who are in self-contained accommodation, so those are the single claimants who are under 35 without dependents, the other two exemptions apply. So if you qualify for SDP or you're under 25 and were looked after. But in addition to that, there's many other exemptions. But the two that I think are most useful are the ones that are recent. So there's one now from October 2022 onwards. If you're a survivor of domestic abuse and you survived that domestic abuse since the age of 16, and you've contacted the person in an official capacity about that abuse, you should be exempt from the shared accommodation rates. And if you are a victim of modern slavery, and you have a positive conclusive grounds decision after a referral to the National Referral Mechanism, you should also be exempt from the local housing allowance shared accommodation rate. And the usual ones applies, which is if you live with a non-dependent, I should also exempt you too. Next slide, please. There we are. If there's no getting around the local housing allowance, you may get a bit of relief from the discretionary housing payment provisions or the homelessness prevention fund. DHP is available where your claimant is entitled to housing benefit or the housing element of UC, even if it's £1. And they require help with their housing costs. And it's always helpful to remember that housing costs under the discretionary financial assistance regulations, so the DHP regulations, has quite a broad definition. So it's your usual rent costs, but it can also cover help with a deposit or even removal costs, so moving costs, all sorts of things. So it can cover the shortfall. It can be paid in lump sum. So where you have a tenant who is now paying their full rent because their benefits were sorted out, but there was a long period of time where they weren't, you can ask for DHP to pay a lump sum in, which is really useful for Ground 8 claims, because there's a very strong argument to make to the council to say it's a lot cheaper for you to help me now than it will be when I'm making a homelessness application. And it can also, if all else fails, and this isn't really about possession claims, but worthwhile to remember, if all else fails, it can also help with a rent in advance or deposit for a new property if you need to move. What it can't do is it can't cover shortfalls caused by service charges, rent increase that are themselves caused by the rent arrears, deductions for debts or overpayments, and any periods where the benefit was suspended. So that's lawfully suspended. It's useful to think about the DHP in the context of homelessness prevention as well. So as you all know, where you are threatened with homelessness and eligible for assistance, the local authority has a duty to take reasonable steps to prevent that homelessness. There's not a huge amount of guidance about what those reasonable steps should be. They need to be put into a proper PHP, and they need to be agreed. But what the Code of Guidance does say explicitly is that local authorities should be thinking about offering financial assistance through the DHP scheme, if that's something that will help you keep the property that you're in. And again, what's important to remember when you're doing a DHP application is that you are doing the council a favour. You're trying to argue that it's much better to accommodate this, potentially homeless family by helping them with a small lump sum to bring down their arrears than it would be to put them in temporary accommodation for God knows how long. So you have to really emphasise the risk of homelessness, and also, where possible, I think this is the main thing really, you have to say that there's an end in sight and that the DHP isn't going to be going on forever. So make clear that, and I'm sure that this will be the case for many clients, that they are taking steps to make sure that they are going to be able to pay their rent in the future, but that they just need a bit of help in the immediate future to avoid being evicted. So as I said before, make sure that they've got as many benefit applications going as they feasibly can. If they're applying for new jobs, make sure that the council knows about it. If they're thinking about taking a lodger in, make sure the council knows about it. On lodgers, it's worthwhile to remember that all secure tenants have a right to take a lodger without the landlord's consent under Section 93 of the Housing Act. What they cannot do is sublet the property without the landlord's consent. And sometimes there's a bit of a delicate balance to be struck there to make sure that they're not accidentally subletting. But the usual principles apply. If you have a situation where you are changing your lodger's linens, you're cleaning, basically you're entering the room without necessarily their advance permission, or where you have strict house rules or any house rules, so things like curfews or rules about when you can have visitors, then that is more likely to be seen as a lodger style arrangement rather than a genuine subletting of part or whole of the property. Obviously, please be wary of advising your tenants to accidentally sublet the property. I think that goes without saying. What is also worth remembering, though, is that whilst there isn't this automatic right to take a lodger for assured tenants, lots of tenancy agreements will have a provision about circumstances where a lodger will be permitted, and most social landlords have a policy, normally a published policy, about when they will accept lodgers, and that is useful when you're thinking about making arguments about why the landlord has not done everything they can before trying to evict the tenant. So if you're trying to argue that it's not reasonable to evict the tenant when the tenant has astronomical arrears, as we're seeing at the minute, or where you've put in a disability discrimination defence under Section 15 and you're trying to argue that it's not proportionate to evict, if at any point you've put your tenant has put in a reasonable request to take a lodger and the landlord hasn't dealt with that, it's worthwhile to remember and to plead in the defence. Thanks, Dan. Next slide. This is just a reminder about breathing spaces, which I think are just going to be more and more useful as we keep going in the cost of living crisis. It's retreading old ground, so bear with me if you guys are all familiar with this information already. But again, it's worth remembering. So the regulations are under the Debt Respite Scheme, the Breathing Space Moratorium and Mental Health Crisis Moratorium regulations. In terms of the debt breathing space, rent and or mortgage arrears will be included. The breathing space doesn't get you out of being liable for the rent in the long run, but it limits what the landlord or lender can do in terms of enforcing that debt for a period of 60 days. So they can't demand payment of the debt included in the moratorium, and they can't charge interest during the duration of the breathing space. So what do we mean by enforcement? They can't serve notice on rent arrears grounds during the breathing space. They can't issue a claim during the breathing space. And they obviously can't enforce possession orders. And it's on the landlord to notify the court if there's a breathing space in place, if they know about it. And once the court becomes aware that there's a debt breathing space or moratorium, it has to adjourn the proceedings to the first open date after the breathing space ends. The other type of breathing space, which is going to be increasingly more helpful, is the mental health breathing space. So that is available to people who are receiving crisis treatment from a specialist mental health service in respect of a serious mental disorder. And I think, and Dan's pointed this out before, I think lots of people will assume that that means that they've been detained under section, but that's not necessarily the case. So if you're receiving any sort of crisis treatment, so that can be treatment from the crisis team at home, that qualifies you for a mental health breathing space. So it lasts for the length of the treatment plus an additional 30 days. You can have as many as you need. It can be on application from the person who's having the mental health crisis or from a third party. So oftentimes the community mental health team can help you to do it. What's useful is it gives you a lot more time than the debt breathing space. So if there are ongoing proceedings, the court has to adjourn generally and then just list for review for a date 6 months after the start of the breathing space. So obviously if you've got high level of rent arrears and you've got a ground 8 claim, that's extremely useful because all you really need is time to try and sort yourself out. If you try to take any steps, if landlords try to take any steps contrary to the regs, that will be void. The court can give permission where it's reasonable and not detrimental to the tenant, but I struggle, maybe I'm not creative enough, I struggle to think of a situation where it would be reasonable to do that. Dan's going ahead. And finally, this is a case that Dan did. Debtors cannot be evicted during a breathing space of any kind. And if they are evicted, they can apply for restitution if they're evicted in error. So that's a useful case to gently remind landlords about to make sure that they don't make any fast moves. Next one. There we are. And this stuff, I'm sure we're all very familiar with, but it's useful to remember again. If you're on the duty desk and you've got cases where the arrears are in the tens of thousands of pounds, these sorts of defences become quite useful. The first one is a deposit counterclaim. You have to make sure that if the tenancy deposit has been paid, that the regulations have been followed to the letter or something substantially to the same effect. And the case of Nugan Swindles makes clear that Parliament put these requirements in place for a reason. So it's for the landlord to show that they've done everything that they can to try and comply. And the useful thing about that is when you've got really high rent arrears is you can at least plead several breaches. So if you have a case where you have several fixed term tenancies in succession, or you have a fixed term tenancy and then a statutory periodic tenancy, if you can reasonably claim that there's been a breach of the regs, you can claim for breach on each occasion of each new tenancy. So you'd be asking for 3 times the value of the tenancy, times however many tenancies you can identify. So obviously that can be, if you paid a £2,000 deposit, that can be a substantially valuable counterclaim, and it can extinguish arrears, or at least on the face of it look like it can extinguish arrears. So useful at a first hearing. Always useful to think about section 15, disability discrimination and other kinds of disability discrimination. So failure to make reasonable adjustments. This isn't just available for social landlords, which I think sometimes people think. You can think about whether it's worth pleading it or raising it at the first hearing against a private landlord, though the situations where that would be sustainable are limited. But one example that I think works in terms of showing that a landlord could have done something to bring the arrears down that would have been reasonable and proportionate to do is where they haven't applied for maybe an advance payment. They haven't spoken to Universal Credit about getting direct payment to Universal Credit, because it seems to me that that's a very easy and straightforward thing for even a private landlord with 1 or 2 properties to do. And that should be the first thing they're thinking about if they've got a tenant who has Universal Credit that isn't going to them. And in more interesting cases where it's very difficult, so cases with non-secure tenancies or licenses, you can have a think about whether there's a sustainable public law defence. The case I've put down there is the Crown and New Caney. And the principle from this is that there is a discretion from local authorities when they are providing suitable accommodation, to potentially charge no rent at all, or charge a very nominal amount of rent if that rent is genuinely unaffordable to the tenant. Obviously, that's going to have quite limited application, but it's worth thinking about if you've got a council tenant who is facing a rent arrears claim and has a notice to quit, worth having a think about whether the council has considered this discretion that they have to perhaps charge less than they're charging, or to charge nothing at all if it's genuinely unaffordable to the tenant. Clearly, if there's things that the tenant could have done to make that rent affordable, you're going to have a hard time. But there's circumstances with the way that benefits are going at the minute where they're just not going to be able to afford it. And lastly, Dan might want to talk about this because it's his case that I'm referring to. But there are ways that you can be creative with the Children Act duties to try and bring down rent arrears. So I don't know, Dan, if you want to talk about your case, or you'd rather I?
Yeah, I'm very happy to. So this is just it happened. We were talking about this seminar on a day when I happened to have finally resolved a fairly long-running rent arrears possession case. And in short, what happened was that it was a 16-year-old, or the tenant, when she had been 16, had presented to the council as homeless, and they had purported to accommodate her under the homelessness provisions, when in fact they should have accepted a duty under Section 20 of the Children Act. And had they accepted a duty under Section 20 of the Children Act, she would have become a former relevant child when she turned 18, entitled to all of the care leaving duties. By the time we became involved, she was either 25 or was about to turn 25, so she wouldn't have been a former relevant child anymore. But in the face of some fairly significant rent arrears, we said that in effect the local authority had acted unlawfully in failing to recognise her first as Section 20 duty, and then therefore as a former relevant child. And had it acted lawfully, she would have had various aspects of support, including a pathway plan, which should have provided for the situation of her facing eviction and getting into rent arrears. And that had all of that happened, she wouldn't have ended up facing eviction. And after quite a long period of delay, the local authority accepted the argument basically and said, yes, you're right, that had we fulfilled our duties to her under the Children Act, she wouldn't be in this position, and therefore we're going to write off her rent arrears. And I think they did it. They divided that up as saying, well, she would have got, I think it was about £2,000 care leaver grant when she turned 18, so we'll knock that off, and then we'll waive the remainder of the arrears because effectively we shouldn't have allowed her to get into this situation. So it's worth just thinking about things along those lines, whether there are other kind of broader factors in public law duties, and that you might be able to say, well, look, you failed, and using the case of GE Eritrea, I think is the most well-known one, to say where you've acted unlawfully and you've got a discretionary power by which you can make good the consequences of that unlawfulness, you should at least consider doing so. So yeah, it's going to be rare and only on very specific factual circumstances, but worth thinking about. Just one other thing, actually, just that occurred to me when you were talking about disability discrimination. One case that I've had recently, another example of where, there are two further examples, I think, of when a landlord might be said, there might be a less drastic course. One of them, of course, always is to say that the less drastic course is to wait for other things to take their course. So if a tenant, it might be that there's nothing the landlord themselves can do, but if there's some solution that the tenant's got in motion that should bear fruit soon, you might be able to say that a private landlord is acting disproportionately in pressing on to evict, when in fact it will be sorted out soon. And a specific example that I had was one where one of the other solutions that Marie mentioned about a homelessness prevention payment, the council had offered, saying, look, we'll clear the arrears if you drop the possession proceedings, and the landlord said no. And you can see in those circumstances, you might be able to say that, well, actually, there is a less intrusive or less drastic course the landlord can take. Sorry, Maria, I interrupted. Are you ready for the next slide?
Yeah, I think that's the end of it.
Oh,
Except one
of
final
course,
slide before we move on to the questions. We've got 10 minutes for questions, so that should be good. Just a reminder that the HILPA conference is on the 17th of November, and you can now buy your tickets. This slide very helpfully has, I think, the prices on there, but drop me an email if you need more information about it. But yeah, hopefully everybody comes on the 17th. And now I think we've got a couple questions. Although I think we've answered them, unless you
we've got one more outstanding. I'll stop the share now, just so that people can see us a little bit larger than that tiny box in the corner. So yeah, I don't know whether I'll hand it back over to Ben for the questions.
I'm going to invite
or not.
Marie. What would you like to talk about the breathing spaces? We're on the
Oh, sure,
claims
Vicky,
based,
yeah.
not
Sure,
on rent arrears, but on ASB.
I think the difficulty is, and I'm happy to be corrected, but they're very much breathing spaces meant to be dealing with debt. So I think you're going to have a hard time. Well, it's not going to be possible if it's just pleaded on the basis of ASB. But I suppose you could arguably say it applies if they're asking. You can certainly apply if they're pleading it on rent arrears grounds as well.
Yeah.
But sometimes they're also asking for money judgments for rent arrears, whilst not pleading the rent arrears ground, but just lumping it in with the possession claim. I suppose you could also ask for it then, that you might have a bit of a harder time.
Yeah, I mean, I think certainly to the extent that they're asking for possession on both grounds, I would agree. I think that you might put them in a position where they have to, or they would either have to perhaps abandon their rent arrears claim, or at the very least I suppose they could ask the court for a split trial, and they could say that the rent arrears possession claim is adjourned, but they're allowed to continue with the antisocial behaviour. I think that's right. That it's certainly not designed to protect against antisocial behaviour possession claims. To the extent that they're kind of intractably entangled, you might get that as a fringe benefit, but a landlord properly advised should probably be able to find a way around that.
And then we had a really interesting question about whether a landlord could rely on ground 8 if rent is payable over or in periods which are not listed under the Act. So, for example, it's not weekly rent or fortnightly or quarterly, but it's for weekly. And I mean, I haven't come across that before, but I mean, my reading is you probably can't rely on ground 8 if you're the landlord, because ground 8 is pretty clear. It lists A, B, C, D, 4 instances when the ground is made out. And if you don't fall in one of those instances, then I just don't think ground 8 is available. But maybe you two have a different view on that. I don't know.
No, I think that's right. And I mean, when the question first came in, I thought, I wonder, what kinds of rent periods might you be talking about? But full weekly, I think, is certainly not out of the question. And I think your answer is probably got to be right, because the different limbs of ground 8 are clearly set out as conditional requirements for the ground to be made out. I wondered whether the landlord might be able to say that rent payable every 4 weeks is rent payable weekly, but by reference to a larger number of weeks. But that wouldn't work, say, if it was 12 weekly, because you couldn't say, well, it's 12 weekly and you're 8 weeks in arrears. But it just, I don't think it would work. So I think that probably is right, and it's certainly worth a run.
Great. I wanted to just pick up on one of the things that you raised, Dan, about rent due under a former tenancy, which I also hadn't thought about. So I think you suggested the example of a tenant who's had a series of fixed term tenancies, and
yeah,
and I thought that it's going to be difficult, isn't it? Because you've got a rolling rent account, and just as with limitation, it's probably going to be open to the landlord to say, well, all right, but I've taken your money due under.
I've taken
or
your money,
paid
yeah,
un-
in
under
relation
this
to,
tenancy, and I've applied it for the old tenancy debt. So even if you're right, even if the act can
yes,
be
I
read
think that's,
as excluding arrears due under a former tenancy by the same tenant, I would have thought you're going to struggle.
I think that's
with
probably
that.
right, isn't it? I think that's the kind of short answer to it, is that most of the time the landlord will be appropriating payments to the oldest debt first.
Mm. Although how that works when the landlord
I don't think
produces
there's any
a,
reason why they can't do that between tenancies.
although I never quite understood how the appropriation thing works when you've got a rent account that doesn't apply payments, or doesn't list payments
No.
in relation to a former debt spec. Anyway, it sounds a tricky one, I think.
I think it probably is quite tricky, yeah.
But one more question. What happens if a social housing provider delays providing a breakdown of service charges 6 months after a rent or service charge increase, and then subsequently issued notice of seeking possession if a tenant refuses to pay? Do either of you want to have a stab at that?
Social housing provider delays providing a breakdown of service charges 6. Well, I mean, it probably depends what the service charge relates to. Certainly if you're talking service charges that are including water resale, for example, those would fall under the provisions that I mentioned. So there is, I'm just under the water resale order, where a request is made for a breakdown and the landlord is a reseller, then I think it's 6 weeks. Possibly, I can't remember off the top of my head. But after that, there's then a cap on it. If it's just more general service charges, I don't think outside of those statutory contexts there is some kind of general statutory provision applying. I think you would probably be in circumstances where you would have a history of charging for items that don't exist. Okay, interesting. I suppose you then might be into contractual principles about kind of general contractual principles. A lot would depend, I think, on the tenancy agreement itself and whether how those service charges were provided for, what they were said to be. I mean, if it was specifically for something which then turned out not to exist, you might then have some kind of breach of contract or failure of consideration type argument. But I think it would depend quite a bit. And just in relation to the delay itself, I think probably that would go to reasonableness, but it might not in itself provide a kind of clear-cut defence.
And then not lastly, is service of an out-of-date Section 8 notice fatal to subsequent possession proceedings? And let's have a quick look at. And
I'm not
I think that
sure what service of an out-of-date Section 8 notice. I'm not sure.
Do you mean one that was you've issued the claim out of time? Maybe.
I think that probably, I'm not sure whether maybe that envisages serving a notice that bears a different earlier date to the date on which it's served, or I'm not sure what that, I mean, the date on the notice itself, the date it's signed, isn't going to make a lot of difference. It's the date it's served, isn't it? And whether it's accurate at the date it's served that will be relevant.
Not the version in existence at the time it was served. Well, I think then you're going to be into the authorities on about whether it's substantially to the same effect. And if it's not substantially to the same effect, then you won't have complied with Section 8, and therefore the court cannot entertain the claim unless it dispenses with the requirement for notice, which it can't do in relation to the mandatory, certainly in relation to Ground 8.
Great. We are just nearing or right on our 7 o'clock deadline. So I think we've got one more query to deal with.
Yeah.
Do you believe that the breathing space moratoriums stop a landlord continuing to trial to obtain a money judgment and possession order under ground 8, 10 and 11, assuming the renters are in the breathing space? Or do you take the view that breathing space relates to the enforcement rather than the obtaining of money judgments and possession orders?
Regulation,
Right.
reference to regulation 10.3 and 10.5. I think that, yeah, certainly it shouldn't proceed. So 10.5 says that subject to 10.7, during the moratorium, the court or tribunal must take all necessary steps to ensure that any action or proceeding to enforce a court order or judgment concerning moratorium doesn't progress. But I think the regulation 7 arguably is broader anyway, because and that's so for those who yeah, I say this having spent a few months this year kind of deep in these regulations, but regulation 10 deals with the court's duties in effect. I mean, first of all, the court, once it's aware of the moratorium under 10.2, must be stayed until the moratorium, any bankruptcy position must be stayed until the moratorium ends or is cancelled. And 3, sorry, this is at the start of the, yeah, any pending action, then such action may continue until the court or tribunal makes an order or judgment in conclusion. Yeah, it's actually, I agree, it's less clear actually. I've been looking at the enforcement side more. I was fairly sure that the regulations were designed to stop things proceeding, but maybe it's a good question. It's less clear than I thought when I started answering this question. So I'd have to have a look, and I'll maybe drop you an email, Jensen, if that's okay.
Mm. Yeah, great. They're really interesting questions, and thank you everybody for attending. The recording will be posted up on the website along with the answers to the questions. So I hope you enjoyed it and I hope you found it useful, but that's all from us. Thanks very much.
Thanks,
Okay,
Bye.
sure. Bye-bye.